rights, the rights of all, emphasis on all people in our country, which rights must be protected, respected, and promoted and fulfilled by the state through its organs. Section 39 of the Constitution provides for the interpretation of the Bill of Rights by promoting the values that underlie an open and democratic society that is based on human dignity, equality, and freedom. The section further places a duty on every court, tribunal, or forum to promote the spirit, purport, and objects of the Bill of Rights when interpreting legislation and when developing the common law or customary law. The applicant has been what we may regard as vulnerable person ever since he set foot in the Republic as an asylum seeker to being an illegal foreigner in a foreign land during a pandemic, and to finally being arrested and detained in circumstances where his constitutional rights conferred by our very own Supreme Constitution were not given regards to. Yes, the issues raise an arguable point of law of general public importance, as it concerns not only illegal immigrants, but also arrested and detained persons for petty crimes during the lockdown.
Well, mustn't I assume for the purposes of today that the court has jurisdiction? I'm here to decide whether, assuming the court has jurisdiction, this new evidence should go. Isn't that the limit of what's before me?
Thank you, Justice, for the question. The court does have jurisdiction with regards to the matter, but not with regards to the evidence that the respondent wants to adduce.
I see. So could you take me straight there? Why is the evidence, why is the admission of the evidence a jurisdictional question?
It is evident that those are constitutional matters of paramount importance, which definitely require the attention of this honorable court that has jurisdiction to hear such a matter. However, with regards to the evidence that the respondent wants to adduce, the court does not have jurisdiction to hear evidence as first instance, as it should have been adduced in the lower courts. Thus, we submit that this honorable court declare this new evidence irrelevant, therefore inadmissible. It's important to note that it will not be only beneficial to the applicant concerned for this court to hear and decide on the main issue at hand. However, it will set a precedent for others in similar circumstances. We are not saying that someone should go through such similar unfortunate ordeals again, but we cannot simply deny the possibility of such circumstances occurring again, more especially since no one really knows for how long we'll be living with the COVID-19 virus. It is already difficult living in such a time with so much uncertainty and questions, but it would be nice, and surely it would provide some form of certainty to know that even through the pandemic, our law will protect us and the court will forever uphold the law. The respondents, however, seem to be of a different view, as they want to adduce further evidence in order to justify their acts, which we, as counsel for the applicant, submit should not be allowed by the court for the following reasons. The evidence that is to be adduced is not relevant to the issues at hand, and the undeniable fact that the expert evidence might not be reliable, as there are no experts in regards to COVID-19.
What is the evidence?
Thank you, Justice. The evidence that they want to adduce is with regards to herd immunity in combating COVID-19.
Yes, and what do they say about it?
They're saying that they want to bring in an expert to tell us more about herd immunity in their presence by way of exposure.
And what will the experts say?
That's for my learned colleagues to clarify on that.
Okay, carry on.
For evidence to be admitted by this court, it has to meet the evidentiary inquiry threshold. The general requirement of the evidentiary inquiry is that evidence needs to be relevant to the issues in proceedings to be admitted by a court. Evidence is deemed relevant if it will assist the court in proving or disproving a fact in issue. Furthermore, once the general requirements of the evidentiary inquiry have been dealt with and fulfilled, then the specific rules of admitting evidence in terms of Rule 31 of the Constitutional Court rules may be applied. Rule 31 allows the parties of the proceedings to submit further evidence relevant to the issues at hand, which of course should be common cause or capable of verification, and it also allows the parties to respond to such submissions made. This was dealt with in the famous Constitutional Court case of Lee versus Minister of Correctional Services, reported in 2013 in Volume 2 of the South African Law Reports on page 144, whereby Justice Nkabinde, paragraph 34, dismissed the application of the amicus to adduce further information because it was not relevant to the case and it did not meet the threshold requirements of evidence. Moreover, the majority judgment in the 2008 Constitutional Court case of S versus Shea at paragraph 19 to 23 dealt with an issue of adducing evidence late. It was held that if new evidence does not meet one requirement prescribed in Rule 31, then it will not be admitted unless there are exceptional circumstances for condemnation. So it's clear that both these cases emphasize the importance of relevance of evidence to a particular case. Yes, we do agree that the evidence may be useful with regards to the facts in issue, but still not be relevant. The evidence that the respondent wants to bring forth will definitely shed some light about herd immunity and the virus in general. However, it is not relevant to the issues at hand. Section 22 of the Supreme Court Act 59 of 1959 with regards to Rule 30 of the Constitutional Court rules.
I was just wondering whether anybody was keeping time. Thank you very much.
In respect for time and this court, the issues that I was going to continue with would be the issue of the expert evidence and why it should not be admitted. We cannot stress this enough. The applicant is not asking this court to determine the legality of the government policy to combat COVID-19. No, what we are saying is that the evidence is just not relevant to these issues.
I have your point, Ms. Bremser. Thank you very much. Mr. Saul. Mr. Saul, are you going to tell me what this evidence is?
No, Justice.
Okay. I sit here quivering with anticipation, but do carry on. Tell me what you have to tell me.
The first respondent intends to make use of herd immunity as a solution to curb the spread of COVID-19. The World Health Organization defines herd immunity as an indirect protection from infectious disease when the population is immune, and this can be done through vaccination or exposing a negative person to a virus to develop immunity. The World Health Organization aims to support to achieve such a thing by through a vaccination rather than exposing the people to a deadly virus that can lead to an increase of cases and death unnecessarily. The proposed evidence to be adduced by the first respondent is unclear and suggests that it will be an involuntary procedure that will expose vulnerable prisoners to a virus without their permission.
So you haven't been told what the evidence is, you've just been told it's coming. Is that so?
Yes, we are only told it's coming.
Oh, I see.
No,
you don't know what the content is?
The content of it.
Okay, it's something I'm going to have to take up with Ms. Smith, but carry on.
Yes, sir. This will result in the unjustifiable limitation of the prisoner's constitutional rights and undermine the principle of legality, as it will violate the prisoner's right to human dignity under Section 10, body integrity under Section 12, and the right to environment that is not harmful under Section 24 of the Constitution. The virus is proven to be deadly to vulnerable individuals with comorbidities. It is common cause that most of the prisoners is a high number of people with HIV, pneumonia, and TB. This means that prisoners who are exposed to such won't survive during this time or have difficulties with their health. To be clear with the Honorable Court, the applicant is not against any solution of herd immunity. However, the applicant submits that herd immunity is not practical to achieve in correctional services for one or more of the following reasons.
What if the government vaccinated all the prisoners? That would be herd immunity, wouldn't it?
However, thank you for the question, Chief Justice. The respondent.
Thank you for the promotion, Mr.
the respondent in their submission, they are trying to achieve the herd immunity through exposing the individuals to the virus rather
I
than
see.
having the vaccination in
Thank
their submissions. We are saying that the clinic is not medical for one of the following more reasons. It's congested. It's a common cause that our prisoners are congested, and we will have difficulties in terms of logistics and medical health workers. Immunity, the country doesn't consider the professional services as vulnerable citizens, therefore, they won't be prioritizing the allocation of the available resources in the country. The inmates reserve the right to refuse to any health treatment as protected by our Constitution. No one can be enforced to any treatment without their approval. The inmates with comorbidities won't survive, and this will make sure that there won't be a large enough amount of people partaking in the herd immunity and therefore making the herd immunity ineffective. There's no guarantee that the inmates won't be reinfected. As we have seen, people are getting reinfection as the current stands, and it's not clear whether reinfection won't happen in our prison.
I accept, Mr. Sulla, that the content of this evidence is a bit of a mystery. But do you expect, or is there anything in what you've been told that will help the court understand why the state thinks that it's justifiable to put people at the risk of death, individual people at the risk of death, simply to achieve herd immunity for others?
Thank you, Justice, for the question. The evidence that the applicant, the respondent seek to adduce, the only information we have about is going to be herd immunity. Whether it will be in benefit of the individual is for the respondent to explain to us, and how it will be beneficial. As we submit the applicant, it won't be beneficial, and we won't be, in the interest of justice, to adduce evidence that won't be beneficial in this matter.
But their case isn't going to be that they shouldn't pay damages because they're doing their best to vaccinate prisoners.
Yes, Justice, we agree with that. In our matter, the client has already suffered harm.
Yes.
That's the issue in hand. We cannot be bringing evidence of herd immunity while our client has already suffered the harm.
Yes. Thank you.
And it won't be a beneficial of our client, nor this court in deciding the final decision of the matter. Coming to the issue of the arrest and the detention of the applicant respects the role of the law enforcement in South Africa, including that of the second respondent, which is the Minister of Police, in enforcing their mandate, which is governed by Section 205 of the Constitution. The applicant is a marginalized foreigner national from Zimbabwe who had to flee his country due to the unrest in his country and flee to South Africa in fear of his life and freedom. His political activists were abducted, beaten, and sexually assaulted, making it an imminent danger, and he had to flee in the escape of being victimized. In terms of Section 39, Section 1, Paragraph C, of our Constitution, this honorable court must consider international law in terms of Section 232. This honorable court must prefer a reasonable interpretation of the law that is consistent with the international law. In terms of the 1951 United Nations Higher Commission Refugee Convention, that it states that no state may discriminate against refugees. The state must provide travel documents to this individual, and the state may not return them to the countries where they will be faced with threat of their life and their freedoms. In this honorable court, in the case of Rota versus the Minister of Home Affairs, which was held in 2019 and reported in the SA Law Report under Volume 2, page 339, in an unanimous judgment by Chief Justice Cameroon, it overturned the judgment of the Supreme Court, which said that the applicants may not apply. There's no reasonable delay in applying. In that judgment, the court held that the Refugee Act is clear. The delay itself does not disqualify an asylum application. The only ground in which the application may be refused is those that are found in the Refugee Act. Further, the delay in the immigration status does not bar the access to the application process. and the first available opportunity cannot lead to disqualification of seeking and qualifying for asylum seeker. As our applicant, we wanted to apply in terms of the refugee reception office. It's unfortunate that during his arrival in South Africa, such offices were closed down during the lockdown, and he was unable to continue with such application. Furthermore, in the case of
And did that lead to his detention?
no, it was the additional charges justice in
I see.
so we are trying to address that. Further, in the case of Ahmed, this is the Minister of Home Affairs, which was in an unanimous judgment by the Chief Justice Peron, he pointed out there are difficulties faced by foreigners to apply for visas while they are in their country. And the Minister of Home Affairs should be allowed to allow this individual to make their application while they're in the country. In respect of the time, he summarized our submission is that the applicant in this matter should have been released in the matter in terms of section 59 subsection 1 of the Criminal Procedure Act and one against for the return in future date in terms of section 56 subsection 1 of the Criminal Procedure Act, as it was a directive issued by the first respondent that clients should not be arrested for petty crimes that they involved in such as that of the lockdown regulation and breaking of the lockdown regulation. Instead, as they alleged that it was a flight risk, they could have been taken to a refugee campsite where we would be in safe control and under control of the client, rather than exposing our client in an environment that is dangerous and congested and overcrowded. They are failing against their own grounds of reducing the numbers. Last year, they issued that due to the COVID, they are released 19,000 prisoners to allow the prisoners won't be overcrowded. But now they are failing in the application of that. So in our final submission that the negligence that happened is a result of the negligence of the respondent in this case. I thank you, Justice.
Thank you, Mr. Song. Were we within time? Good. Mr. Nkosi. Just remind me what you're going to address me on.
Thank you, Justice Wilson. We're dealing with the substantive law with regards to admission of evidence,
Yes.
admission of evidence.
Yes, thank you.
Also, we deal with the closing arguments for the applicant.
Yes, well, you'll reply, in other words. Or,
No, that I'll do after.
yes, yes.
Yes.
Yes, you'll reply when there's something to reply to. Yes.
Yes. Thank you, Justice. Justice Wilson, submission by the applicant is pretty straightforward in the sense that we are saying that this court should not be the court of first instance. The reason being is that we're looking at the Faro case, Prophet, rather, besides the NPA, the Constitutional Court decision that was reported in 2007, volume 6, starting from page 169. In that case, Justice Ngabinde laid out two ways in which late admission of evidence, the procedure should be followed. Firstly, it was Rule 31, and then secondly, it is Rule 8 of the Constitutional Court rules. The reason being I'm bringing in Rule 8, though the respondent is not using Rule 8, is because of the importance of this matter we're dealing with today.
What does Rule 30 say?
Rule 30 says that admission of late evidence is allowed under exceptional circumstances or special grounds if it is weighty and believable. So there are two factors to look at with regards to that, Justice. May I continue?
Yes.
So, because my first co-counsel has already discussed the issue of Rule 31, I will just focus on Rule 30, which is incorporated by Section 22 of the Supreme Court Act 59 of 1959. We submit as the applicant that there are no special circumstances in this case to allow the admission of this late evidence. The reason being is the fact that herd immunity is not a thing that came with COVID-19. We have already faced the Spanish flu in 1920, we have dealt with polio, we have dealt with tuberculosis, we have dealt with HIV.
I think all of those were under a different constitutional dispensation.
Yes, thank you. So in all of those pandemics that were faced, the issue of herd immunity was there. So it would have been under exceptional circumstances if herd immunity was not a matter of discussion even then. So our submission to this court is that herd immunity has been discussed through, has been researched, and there are also prerequisites on how to go about herd immunity. As defined by my co-counsel what herd immunity is and how it is offered. It's offered in two ways. It's either through vaccination and through exposure. In this instance, I'll take you to what the World Health Organization say we must go with herd immunity. The World Health Organization says that herd immunity must be executed through vaccination. Reason being is because of safety protocols and health standards that must be looked at first before such an execution is done. And therefore, they discourage any exposure that is unwarranted and that cannot be classified through medical research. So that's our submission in terms of why the late admission of evidence cannot even be admitted through Rule 30 of the Constitutional Court rules. I was answering the question my co-counsel referred to me earlier.
Yes.
Moving forward with my submission, also looking at the Prince case, which is Prince versus President of the Law Society of Good Hope, reported in 2002, which actually laid out that if late evidence can be admitted, if the facts that are supposed to be submitted to the court are not disputed. Now, when you look at the area case which I referred to, which is the MPA case.
That's Rule 31 now. Oh,
yes, that's Rule 31. Now I'm getting to my substance.
We're in Rule 31 now. Good. Yes.
I'm going back to the substance, Justice.
Thank you.
As I was saying, the Prince case, the Justice over there held that Rule 31 allows for the admission of evidence if it meets the evidentiary burden, but it must not be disputed. However, it cannot be allowed if the submission of the applicant, of the person that's trying to adduce the evidence, those submissions are genuinely disputed. Now, Justice, I will take you back to the earlier case which I was referring to, which is the Prophet versus the NPA case. There's two cases in comparison. The NPA case, which dealt with an unopposed application, and the Prince case, which dealt with an opposed application of late evidence. While we focus on the issue of the NPA case, is that even if it's unopposed, it still needs to meet the evidentiary burden insofar as relevance is concerned. So relevance in any event is a must when it comes to the admission of
that's why I keep asking what this evidence is, because I need to know whether it's relevant or not, don't I?
Well, so
I'll speak more slowly. That's why I keep asking what this evidence is, because how can you know whether something's relevant if you don't know what it is?
Thank you, Justice. In terms of the directive that was issued by this court on the 4th of January, it says that the first respondent intends to adduce further evidence in terms of Rule 31, and therefore the directive further explains that the admission of this evidence will be done through the exposure of the pathogen to the prison community. Therefore, we are allowed to make those assertions that exposure. Okay, yes. Thank you, Justice.
So the fact sought to be admitted is a plan by the respondents to pursue herd immunity through exposure rather than through vaccination. And the question is whether or not the truth of that fact is relevant to your client's claim for constitutional damages.
Thank you, Justice.
Thank you, that's extremely helpful.
Yes. As I continued my submission, Justice Wilson, I was still dealing with the issue of the principles laid out by Justice Ngo in the Prince case.
Yes.
So the main issue is relevance. Relevance remains the biggest factor of admission. Within our South African law of evidence rules, the general rule is that evidence must be relevant in order for it to be admissible. Vice versa, if evidence is not relevant, it is immaterial and inadmissible. Therefore, as the applicant, we are genuinely disputing the admission of this evidence based on one, the evidence that is going to be adduced to this court is not relevant to the evidence that the plan that the respondents wants to imply or impose on the respondent will risk the prisoner's lives going even forward.
But isn't Rule 31 about the truth of the evidence, not its relevance? You can dispute the truth of something, and the point of Rule 31 is that if you disagree with the content of the fact, then the evidence can't be introduced.
Yes, that's our submission.
So why is the content of the evidence disputed?
I'll try to answer as I hope I'm clarified with your question because of time. Hence, I
You started to your finish.
Yes, I did a comparison between the Faro case,
Yes.
Prophet case, and the Prince case, which dealt with when the evidence is opposed and when it's unopposed.
Yes, but opposing the introduction of evidence is not the same as saying that the evidence isn't accurate, is it?
Yes, we are not saying the evidence is not accurate.
Okay,
We
thank
are
you.
not saying that.
Right.
And to refer you as I close my submissions because of time,
Yes.
refer to the unanimous constitutional decision of the amicus curiae in the Minister of Health Research Treatment Action, whereby the court said that usefulness of the evidence does not automatically say that the evidence is relevant. So therefore, we do admit as the applicant that head immunity in general is relevant, and so rather it is useful, but it is not relevant insofar as achieving, helping us in dealing with the pandemic. Two, we need to understand that the applicant has suffered harm in this regard, and therefore we cannot use head immunity to escape the point of law that's being argued that the respondent was negligent, did not take reasonable steps to alleviate the matter or mitigate the problem that is arising. With those words, justice, Soweto towers can never be Egyptian pyramids. Thank you.
Thank you, Mr. Nkosi. Ms. Smith, are you up for the respondents now?
Yes, Justice. Good morning, Justice. My name is Samantha Smith, and I will be appearing on behalf of the respondents in this matter before the court. Alongside me is my co-counsel, Ms. Winnie George, and Mr. Papazotsumi.
Yes, thank you.
Justice, this entire case comes down to one word: reasonableness. This case is not a case about emotions, but the realities faced in correctional centres due to the dynamic landscape of COVID-19 and how the correctional service authorities acted reasonably in trying to prevent the applicant from contracting COVID-19. As COVID-19 is a very new pandemic and hasn't been present for an extended period of time, the respondents acted as best they could with the available information, and our evidence that we wish to submit today will showcase that. Justice, I will be speaking for 10 minutes and will address our argument relating to the medical expert's evidence. Ms. Winnie George will speak for 10 minutes and will address how it is in the interest of justice to admit this evidence. And lastly, Mr. Matsuli will also speak for 10 minutes and address our argument relating to judicial reference. If it pleases the court, I will now continue with my main argument.
Yes.
I will be addressing the court on two main issues. Firstly, how the respondents comply with Rule 31 and the two requirements thereof, namely relevance and common cause, in order to allow us to adduce this evidence. Secondly, that even though this application is late, there is a reasonable explanation therefore, and thus we ask this court to allow the evidence we wish to adduce. According to Rule 31, subsection 1 of the Constitutional Court Rules, there are two requirements that need to be met. Firstly, relevance, as set out in the Mail and Guardian Media versus Chico case at paragraph 11 of that case, and secondly, common cause. With relation to relevance, the information we wish to submit will show that the correctional service authorities acted reasonably and as a result prevented the unnecessary loss of life. When we refer to reasonableness, we are referring to the Lee versus Minister of Correctional Centres case at paragraph 82, where it states that the law does not require the correctional service authorities to ensure that the applicant will not contract the virus such as COVID-19, but only to put in place adequate and reasonable measures. If we look at past pandemics, we can see that herd immunity can only be achieved in one of two ways: either through vaccination or through the natural herd immunity process. The applicants wish to suggest to this court at paragraph 26 of the heads of argument that we should wait for vaccines. Respectfully, Justice, we wish to submit it is irrelevant if we are waiting for vaccines or not, as this process has already occurred. Thus, we are before the court. These proceedings are not about injunctive relief or prohibiting the respondent from following this process, as it has already occurred. Thus, as I have just stated, and as said in paragraph 24 of the Statement of Agreed Upon Facts, vaccines were not available when the applicant was incarcerated, and thus the only other alternative to vaccination, herd immunity through vaccination, is natural herd immunity.
Well, you could have locked down as a prison.
Justice, we did lock down for a period of time, but as the regulations stated under the Disaster Management Act, when the prison went into level 2, the prison reopened, and we can only comply with the policy as it states, as it is stated.
So, what was wrong with the level 2 regulations then?
Nothing was wrong with the level 2 regulations, Justice. I'm merely stating that we complied with it as we went full lockdown up until level 3, and then when the country went into level 2, the restrictions eased a bit.
But is your case that level 2 regulations were insufficient to stop the virus from spreading in prison?
No, Justice, not at all. Our submission is that the Correctional Service Authority pursued natural herd immunity in order to prevent the unnecessary loss of life. For instance, the applicant, as in this case, as when this case was heard, vaccines were not available, and this was the only other alternative to achieve herd immunity. As the applicant has also stated, herd immunity is the best protection you can give in order to prevent a virus such as COVID-19 from spreading.
Whose lives do you save by just letting the virus spread?
Justice, what we are doing, so herd immunity is the best protection in order to prevent people from dying. So we did not allow it to spread. We did institute reasonable and adequate measures, but the natural approach of herd immunity is what occurred. It was not an intentional process as such, but that is what happened. But we did institute reasonable measures, such as instituting hand sanitizer, screening all incoming inmates, providing masks for the people who provide the food for the inmates, also releasing inmates in order to adhere to social distance protocols. If I may refer, Justice, to paragraph 9 of our supplementary heads of argument relating to the common cause aspect of this case. Common cause, as explained in the Erasmus Superior Court Practices, Volume 1, means that the accuracy of the information is not disputed. And as said in X versus Lawrence in paragraph 25, expert evidence can be taken into account when deciding a matter on appeal if it falls within the scope of Rule 31. As said in the applicant's head of argument at paragraph 23, and thus we agree it is common cause that herd immunity is the best protection against a contagious disease such as COVID-19.
Well, they say herd immunity by way of vaccination, don't they?
Yes, Justice. So they
It's
say
not common cause, is it at all?
it's Justice. It is common cause that there are two approaches, yes, we agree with that. And we are stating that when this case was heard and when the applicant was incarcerated, vaccines were not available. Thus, the only other option in order to achieve herd immunity was through the natural herd immunity process.
Yes, but that's not the proposition that they agree with, is it? They say that herd immunity is desirable only through vaccination. You say that herd immunity is achievable only through controlled exposure, which presumably they would have a problem with.
Justice, the government's long-term goal is to vaccinate the inmate population. But at the time of the applicant's incarceration, that was not possible. But that is our long-term goal, and as soon as vaccines become available to us...
That's fine, it's just not common cause, is it?
Justice, it is common cause.
You don't agree on how herd immunity should be achieved, in other words.
Justice, we agree there are two ways to achieve, and that the one way...
Yes, that's common cause.
Yes, Justice. Thank you. In Profit versus National Directorate of Public Prosecution at paragraph 38, it was held that it is in the interest of fairness to allow this further evidence if there is a reasonable explanation of why this application is late. That is in accordance with Rule 30 of the Constitutional Court rules. When this case was initially heard, COVID-19 was still a rapidly changing pandemic, as said in the ESO judgment at paragraph 155, and thus the respondents could only submit preliminary information at the High Court. But now, as the information has gone through further research and the rigorous peer review process, we now wish to submit the matured information to this Honourable Court. Justices, in conclusion,
So was the pre-peer review evidence before the High Court?
just as the preliminary information that we had available was presented at the High Court, but now that we have the further research...
Did you present expert evidence at the High Court?
No, Justice.
Thank you.
Thank you, Justice. Justice, in conclusion, I would like to summarize that the reason we are standing here before the court is to determine if this evidence will showcase that the respondent's actions were reasonable. And only that. No drama, no emotions, no theatrics. We are only here to determine the facts. The respondents therefore submit that the information on what herd immunity is, how it works, and how it can be used as a public health strategy will support our primary contention that the Correctional Service Authority acted reasonably.
And where does that get you in the main case?
Justice, the proceedings in front of you are only relating to the adducement of the further evidence.
Yes, but that's exactly why my question's relevant. If you establish that your path, that the steps you took were reasonable, where does that get you in the main case? What does that allow you to say in the main case?
Yes, Justice. So if this evidence is introduced, it will showcase that we acted reasonably in trying to curb the spread of COVID-19 in prisons and preventing the unnecessary loss of life, which will showcase that the applicant is not entitled to damages, as the legal causation requirement in the merits case will not be met, because there was reasonable and adequate measures instituted as best we could at the time.
So your case on the merits is if you acted reasonably, you don't owe the applicant any money. And if you didn't act reasonably, you do.
Yes, Justice.
Thank you.
Thank you, Justice. In conclusion, the respondents submit that the information on what herd immunity is, how it works, will support our primary contention. If there are no further questions, I would now like to hand over to my co-counsel, Ms. Winnie George.
Thank you very much, Ms. Smith. Ms. George.
Yes, Justice. Good day, Justice. As previously mentioned, my name is Winnie George, and I appear on behalf of the respondents in this matter before this Honourable Court. The applicant is alleging infringement of his constitutional rights in the context of COVID-19, and therefore this case sets great precedent for future cases and is of great public interest. However, that is not why we stand before the court today. We stand before the court because the respondents in this matter would like to adduce further evidence, and therefore I will be talking about how it is important to adduce this evidence because it is in the interest of justice. Specifically focusing on the criteria set out in Children's Institute versus Presiding Officer of the Children's Court, in accordance with Rule 31 of the Constitutional Covenant. If it pleases the court, may I direct the justice to paragraph 12.
Before you go there, is the application made under Rule 30 or 31?
Rule 31, Justice.
Okay, so I can safely set aside the arguments I've heard in relation to Rule 30 and why you haven't met those requirements because you don't rely on it.
Yes, Justice.
Thank you.
If I may refer the court to paragraph 12 of our submitted aids of argument.
Yep.
Section 173 of the Constitution gives the Constitutional Court the inherent power to regulate its own processes, and this includes allowing the respondent to adduce further evidence, but if it is in the interest of justice. Now, the children's case that I previously made reference to sets out principles that should be followed when evaluating whether the introduction of justice is in fact in the interest of justice. The first and what might be the most important one for this matter before the court can be found in paragraph 16 of our heads of argument. And this just basically says that the court should be wary of refusing evidence when the matter involves constitutional issues concerning vulnerable groups. Therefore, we the respondents submit that as this is a matter where the
That's
court...
listed as the fourth reason why the evidence should go in your head.
Yes, it was listed as the fourth reason in our heads, but we are submitting it in our oral set.
It's been promoted.
We do not list the reasons in order of importance.
Thank you.
Thank you, Justice Orphan. We submit that as this court is faced with a constitutional matter revolving a prisoner which may be considered one of the most vulnerable groups
groups in our society, the respondents submit that this court should apply caution in this matter and should consider the fact that this evidence that we are applying to submit at this point will prove that the respondents acted reasonably with the limited time and resources available to the public sector. This is a sensitive matter, Justice, and therefore the courts should be presented with all the relevant evidence and facts in order to arrive at a just outcome.
So the more reasonable, the more vulnerable the applicant, the nicer I should be to the state.
No, Justice, I am saying that because this is a matter that concerns a vulnerable group, the court should apply caution in deciding this matter.
Okay.
Not that he should decide to apply caution in hearing our case. Furthermore, in paragraph 14, the evidence of our submitted heads of arguments, the evidence must provide assistance to the court in the adjudication of the matter before it. In the case of Lee versus Minister of Correctional Services, it was established that the law does not require a person to guarantee that inmates will not be infected by an infectious disease such as COVID-19, but rather to take reasonable steps to prevent the spread thereof. Now, we submit that the applicants in paragraph 26 of their written submissions have stated that the vaccinations have been procured by Health Ministry and thus this is a better health protocol to achieve herd immunity. However, we, the respondents, submit that at the time of the applicant's arrest and further detention, we did not have access to vaccinations. In fact, they were still in the production phase. And therefore we submit that if this evidence is allowed by this honorable court, it will illustrate that the respondents acted reasonably. And thus this evidence regarding herd immunity and its implementation thereof is crucial to the adjudication of the matter before the court. Thank you, Justice. Furthermore, on paragraph 13 of our submitted case of arguments, the evidence should assist the court in arriving at a just outcome. We, the respondents, submit that if the request to adduce new evidence is denied by this honorable court, it will unfairly restrict the respondent's case. As this evidence, as I've previously mentioned countless times, it will prove that the correctional service authorities did not limit the inmate's rights unjustifiably, hereby making the court proceedings highly prejudicial and subsequently leading to an unjust outcome. Finally, the evidence must be relevant.
Yes.
This means that there must be a logical connection between the submission and the material issue before the court. The respondents therefore submit that as this matter revolves around COVID-19 and the prevention of the spread thereof, introducing further evidence that will demonstrate the gravity of the situation faced by the correctional service authorities and the reasonability of their consequential actions is indeed relevant to this matter before the court. In conclusion, on account of all
So the question is reasonableness, is
it's
it?
reasonableness and legality.
Tell me about legality for a minute.
This just basically implies that the correctional services did act in accordance with the law at that time, which is, in this particular matter, the Disaster Management Act.
What
regulations.
law authorized your client to intentionally expose people to COVID-19?
Thank you, Justice. As my counsel has mentioned, we did not intentionally expose them to COVID-19, as there were preventative measures implemented, which is like vaccination, sanitizing and social distance. And she also mentioned that the president did release a few.
But then what is the policy of herd immunity?
The policy.
If your policy is to restrict the transmission of the disease, what is the policy of herd immunity? I thought the herd immunity you were pursuing is just letting it spread in a controlled manner.
Yes, the essence of
You can't ride both horses. You can't rely on Ms. Smith saying that you did everything you could within the bounds of level 2 to stop the disease from being transmitted, and then on the other hand, say that your policy is to allow the disease to transmit in a controlled manner. But what is the policy?
The policy of allowing the disease to be exposed in a controlled manner will have the overall effect of reducing the curve of COVID-19, which means in the final form, it will reduce the amount of people that are infected with this disease.
So the level 2 restrictions aren't meant to be completely effective.
We are not submitting that, Justice Wilson.
You're not submitting that they are, or you're not submitting that
We're not submitting that the level 2 was not completely effective. We are submitting, however, that with level 2 and the herd immunity, we did work reasonably in order to reduce the curve of COVID-19.
I see. Carry on.
In conclusion, on account of all I, as the counsel for the respondents, have submitted before the courts today, and further information available in our submitted heads of arguments, we, the respondents, submit that we should be given the opportunity to adduce further evidence as it is in the interest of justice. If there are no further questions, Justice Wilson, and if it pleases the court, I would now like to hand over to my co-counsel, Mr. Tabo Matule.
No further questions. The court is very pleased. Thank you. Mr. Matule. Couldn't read my own handwriting. Thank you.
Humble greetings, Justice. I'm Mr. Tabo Matule, representing counsel for the respondent in the case before the court. As established by co-counsel Ms. Smith, I shall be meeting for a total of 10 minutes on the argument that judicial deference is on the paramount letter when watering the seats, which is maintaining the separation of powers. Taking into account that the state had to implement extraordinary preventative measures in such an extraordinary time, being the best to combat the pandemic. Justices, Section 172 of the Constitution of the Republic of South Africa regulates the powers of the courts in hearing constitutional matters. In such sense that the court is entrusted with the utmost responsibility to invalidate matters inconsistent with South African constitutionality. These provisions also allude that rulings should only be found to declare invalidity and inconsistency to only the extent of such a matter.
Is this a case about a declaration of invalidity?
No, Justice.
Okay.
Please allow me to continue.
Absolutely.
Such ruling should also be found to be just in vain. Justices, counsel for the respondent submits that justice only hears our case or judges our case based on reasonableness and legality. Justices, we also have that the Honorable Court allows the respondents to produce the evidence as such being sync with the interests of justice. As it may please the court, the justice referred to page 8 of our supplementary submissions.
Yes. Page 8.
Please refer to paragraph 20.
Paragraph 20. That was very deftly done, Mr. Matuli, because your heads of argument don't have page numbers. Paragraph 20, there we go.
As reads, judicial self-restraint is a self-imposed restriction on judicial decision-making.
Yes.
To borrow the essence of Associate Professor David Brandt, his article titled Judicial Deference and Democracy states, the judicial strategy of deference is of deferring from the other branches of government, justices, as read on paragraph 20, when the judiciary preserves its position, it enables the branches of government, to both the executive and the legislative branches, to develop state policies. Justices, counsel is not relegating the constitutionality and legitimacy of the court presiding over this matter. What counsel for the respondent submits is that this court should concur with Subramanian.
Well, how is deference relevant to the decision of whether or not to introduce evidence? It's a quintessentially judicial question, isn't it?
Thank you for your question, Justice. Justice, the connection of judicial deference to the question of admissibility of new evidence. What we ask of the court is for the court, when hearing or reviewing our case, to exercise some judicial deference. Also, when reviewing or evaluating the evidence that we hold to adduce in front of the court, to also exercise a sense of judicial deference. Justice, please provide a better context.
It's not in yet, is it? So why am I evaluating it?
Justice, futuristically speaking, as we are speaking before the court to adduce further evidence, we also request of the court that we're evaluating such evidence to exercise a sense of judicial deference.
Well, if you get there.
Thank you, Justice. Justice, we ask the court to concur with the Subramanian case that those better equipped than the court continue to manage the national state of disaster. Justices, as reads under paragraph 20, what the separation of powers means is that the court cannot set aside decisions by the executive simply because the court does not agree with means chosen by the executive. The wisdom of the executive is not justiciable, only the legality thereof. Justices, taking into account that the respondent has been trying its utmost best to observe and remain abreast national policies and protocols regarding to COVID-19, Counsel submits that the court should at least commend the Department of Correctional Services for the efforts to combat the pandemic, as opposed to relegating the position of the respondent in this matter before the court. Justices, all three branches of government played an impeccable role in combating the pandemic. Albeit this is an extraordinary case, it is known that such matters are only being heard now before the court. In the case of SU and others, with the Minister of Culture, paragraph 45 reads as, a general rule, policies formulated by the executive will not be right for review until such policies have been implemented. Furthermore, reasons that the mere fact that the formulation of the policy is seemingly flawed does not diminish the latter essence of such policy. Thus, Counsel for the
Mr. Matuli, I don't want to flog a dead horse here, but no one is asking the court to declare anything unconstitutional. Nobody is asking the court to review or set aside any decision of the state. This is a case about compensation. And you're quoting to me a large number of cases about deference in the context of review, effectively. I still don't see the connection.
Justice, I find it of paramount importance to understand that these are points eliminated. If it may please the court. Thus, Counsel submits that the court allows the latter to reduce further evidence as in the best interest of justice. Also, in the case of International Trade Administration Commission, v. South Africa, paragraph 95 to 101 reads, the more a matter before the court is to be found to be policy related, is the most common instance whereby a court is expected to respect the exercise of the power of those in other branches of government. In the case of Law Society of South Africa and others, the President of the Republic of South Africa, the Constitutional Court reasoned, a court should be slow to impose obligations upon government which would inhibit its ability to make and implement policy effectively, to allow the executive to effectively and efficiently and promptly deal with matters. The court further pronounces such a principle as well recognized in our common law and that of international states. Justice, in conclusion, Counsel for the respondent submits that it is of paramount importance for this court to allow for a manifestation of protecting South Africans' socioeconomic rights in the sense of lending an ear to a medical expert on the argument of pursuing her immunity. Furthermore, the respondents conclude that this honorable court should allow the respondents to submit further evidence as such would be in sync with the interests of justice. Principles of good governance should also be manifested. As we may please the court, may justice refer to page 10 of the Counsel's supplementary head of arguments.
Page 10, paragraph 10.
The respondents pray that this honorable court grants an order which will allow the respondent's application of adducing for the evidence as medical research, as well as an expert medical testimony. If there are no further questions,
that's the relief you seek.
The respondents have submitted their case, we raised.
And costs in the appeal?
No costs.
No costs. It's very generous. Thank you, Mr. Matuli. Mr. Corsi, is it your turn now? Quick reply.
Yes.
Thank you.
Justice Wilson, would you please, refer to a directive, the 4th of January directive?
The 4th of January directive, it's here somewhere. Here we go.
The reply that we have in relation to oral submission by the respondent are based on that directive. I will further explain why. Firstly, I think we need to start with the oral submission of the debt speaker, which are dealing with judicial difference. First of all, the application before this court does not in any way deal with any policies that must be set aside, declared unconstitutional or invalid. Therefore, it does not link with the matter that this evidence before this court is relevant. Therefore, they are saying that it should be admitted. As a first point of instance. Justice, the first counsel stated that the vaccination of prisoners is a process that has not been concluded by government, meaning that they are still awaiting for vaccine.
Has it been started?
It hasn't been started.
No.
Yes. So we would like to refer to the respondents to the decision that was made on the 9th of January 2021 by the coronavirus task team, the National Coronavirus Task Team, which was announced on the 11th.
Is that the task team? Is that something different from the command council?
Yes, it's the command council.
It's the command council.
Yes.
Yeah, okay, there we go.
Thank you, Justice. The Command Council on the 11th of January 2021 stated that the vaccination of prisons will actually occur within phase 2 of the vaccination rollout. May I remind this court that today is the 15th of April 2021, and such a process is supposed to start on the 1st of May 2021, according to the decision that was made and announced by the President on the 11th of January 2021. Hence, I had to refer you first to the directive that was issued by this court. Therefore, the respondent failed dismal to prove that the evidence they want to adduce to this court is relevant. They keep on running away from the fact that the evidence should be relevant and admit that the court should consider reasonableness and legality in the matter, rather than stating why the evidence is relevant. The reason why we bring this to this court is the fact that the general rules are very clear, they are not vague. They are quite clear that whenever evidence is admitted, whether within the lower courts or even in this court, relevance remains a prerequisite for adjustment.
So I'm sorry, how does the target date for rolling out vaccines in prisons make their evidence irrelevant?
Thank you, Justice. I was just going there now. I might as well. Yes, the date is relevant because the respondents are saying that the execution of their approach, which is through exposure of the pathogen to the prison community. Therefore, why go to such great extent while you already have an approved program that will actually assist the prison community insofar as achieving herd immunity is concerned?
When did the applicant contract the virus?
The applicant contracted the virus, I think it's now the statement of agreed facts.
Yes.
It's somewhere in...
Well, he tested positive on the 15th of September 2020.
15th of September 2020. And they brought the application on the 4th of January 2021.
What might have happened between the 15th of September 2020 and the 4th of January 2021?
Sorry, Justice?
What might have happened between those two dates? I mean, was there such a thing as a vaccine on the 15th of September 2020?
No, only trials were being run during that time. Therefore, that's why we are referring to the approved decision by government that was taken on the 9th of January when announced on the 11th of January 2021. Because if this court says that the approach that they want to take, which is still in moot and has not been executed insofar as their oral submissions are concerned, and the court admits...
Isn't the point was that was the approach taken at the time? It's not the approach they want to take. They want to vaccinate people.
No.
Just the point is that this was the only approach available to them at the time. So that wouldn't necessarily bear on relevance, would it?
I beg to differ, Justice, on the grounds that, first of all, their application is based on futuristic. Let me just quote the counsel on futuristic application of the approach itself.
I'm not sure I understood what that meant.
Yes.
I'm not sure I understand what it means when you say it either. I mean, this is about something that happened in the past.
That happened is Justice.
Yes.
We agree on that part, that's something that happened in the past. However, on the current day, which is today, the 15th of April, we submit that the decision that was taken by government on the 9th of January 2021 should be the one that is implemented, which is in line with the world standard health that are designed by the World Health Organization, which is achieving herd immunity through vaccination. The president further went on with the health minister, Mr. Zimkiza, that exposing anyone or any Route 1, which will be achieved through exposure of the pathogen to the prison communities. The word in itself does not imply that the approach has already been in execution. However, we are facing...
Paragraph 2 doesn't say it either way. I mean, it just says, intend to introduce further evidence in form of expert medical testimony supporting the first respondents' approach to pursuing herd immunity. It doesn't say future or past approach.
Exactly.
Mustn't I read that as the approach it took at the time?
Just
being a claim for damages.
Yes. The respondent has not in any event done the approach that is being asserted in that directive. The reason being, I'm referring to
these aren't their words, these are ours.
I know, Justice. Hence, I'm referring to the statement by the Minister of Health in August.
Yes.
Last August, whereby they were discussing the matter of exposing people to the virus itself. In the interest of time, Justice, as I conclude our submission, the fact that expert evidence, our argument before, as my co-counsel has stated, is that they are through researching in the World Health Organization had made it clear that they are not experts in COVID-19. Therefore, there is no expert evidence that can be said that they have to introduce at this point in time. Therefore, as we close, we are not asking this court to set aside any policy, government decisions that were taken in how they adjust, not in how they adjust, in how they decide on how to cap the virus. However, such decisions must be in line in saving lives, and choosing this type of evidence can have effects going forward in ensuring and endangering the lives of vulnerable prisoners. In closing, as I close, Nelson Mandela once uttered the following words: "It is said that no one truly knows a nation until one has been inside its jails. A nation should not be judged by how it treats its highest citizen, but its lowest one." Close quote. Justice, the respondents must not be allowed to adduce such evidence, and to be dangerous, be deadly, and can kill the prison community. Thank you.
Thank you, Mr. Post. So, I won't deliver a judgment. We have a limited amount of time before lunch, and I just want to give you each a little bit of feedback. I'll do it generally. I won't pick on anyone. But can I just ask, you're all law students, is that correct?
Yes.
And first year, second year, third, fourth? Okay, so you're knee deep in your law degree. Well, I have to say, the level of spirit and presentation and the acquaintance with the issues that you've each shown is really excellent and very encouraging. I don't know whether I was selected for this assignment for these reasons, but the last time I appeared in the Constitutional Court, it was on a claim for constitutional damages, and there was an application to introduce new evidence. So this is fairly new, this is fairly recent territory for me. And you had to deal with it in the way that I had to deal with it. The people who wanted to introduce the evidence spoke second. And the people who I wanted the evidence out, and I was suing the government. The government wanted the evidence in, I wanted it out. But I had to speak first. And you're constantly having to prove a negative. You're constantly, before they've motivated anything, before they've told you what the evidence is, before they've told you what their case is going to be, you have to anticipate it and say why they're wrong. I mean, particularly for the applicants team, you did that very well, because I asked you lots and lots of questions that you didn't really have the answer to. At some point, someone referred me to the directive. I think it was you, Mr. Nkosi, or was it you, Mr. Sulman? And that was very expertly done, because that's really the only information you have on the papers about what this evidence is going to be. So well done with that. It's a very difficult thing to do. It's a very high degree of difficulty. I think that whoever devised this Moot problem was perhaps being a little bit cruel, because the issues at stake are technical and complex, and I have to say the case that I argued recently engaged them all. The nature of constitutional damages, whether reasonableness is relevant, whether one should be deferent in deciding whether or not to award damages. These all came up in a variety of different ways, and it was hard. The hearing was 6 hours long. I wasn't on my feet because I was doing it over Zoom, but I was speaking for 3 to 4 hours. It was a really, really difficult hearing. And when the judgment comes out, it will be new law. And so here you are in your second or third year at law school, having this problem put on you. You've handled it really, really well. And I think you should all be congratulated. I was particularly impressed by the way the applicants managed to zero in on the nature of the questions of the evidence, and I mean, I'm tempted to call it the somewhat opportunistic latching onto the issue of reasonableness by the respondents was nonetheless very skillfully done. So congratulations there. These moots and advocacy training generally, and at the bar I train practicing advocates as well. I'm one of 30 or 40 advocacy trainers. And if you ever come to the bar in a few years' time, you'll go through formal advocacy training. And the first thing I always say to very much more experienced lawyers is advocacy training and moots of this nature aren't about being perfect. They're not about even being particularly good. They're about getting better. You will all have a particular base that you're working off. And the point of these competitions, the point of these training sessions is to be better. And it doesn't matter whether you are a philosophy student, as I was when I did my first moot. I wasn't even studying law. Or whether you are the Chief Justice of the Constitutional Court, or Wim Trengo of SC, or whoever else is your favorite legal superstar. Everybody can be better. Everybody has an opportunity to improve themselves, and it doesn't matter how good you think you are when you walk into the training session. You'll always walk out being a little bit better. So in that spirit, I have some general observations, and again, don't take them as black marks. They're not. They are things you can think about the next time you're on your feet. And being an advocate in particular is constantly reviewing your performance, especially now everything's on video and you can watch yourself several times, which I obviously don't do. You're constantly looking at ways to improve yourselves. What I would, all of you, and this is for every single one of you, had written down your arguments speech-like. Now, I can understand the security that gives you. And there have been times when I've been tempted to do that, even as a practitioner. What I'm going to suggest to you is that you should get away from doing that as quickly as possible. Because while the written speech is a security blanket, your words are there and you can hold on to them, and they make you feel better. And they give you somewhere else to go once the judge has interrupted you and taken you 20 miles away from what you wanted to say. They take away your agility. They take away your ability to respond flexibly to questions, to engage with the arguments, and to move from one question to another. If you have a speech written down, it's like a pair of rails, and you can't deviate from the rails. And especially in the Constitutional Court, where you have up to 11 justices firing questions at you. I mean, imagine what you just went through, and then imagine 11 of me. And that's a dreadful thought, isn't it? The idea of having a speech that you're just going to read out in those circumstances is a bad one, because you'll be taking questions that are going to take you off your main line as much as possible. What I try to do when I'm appearing in any appellate setting or any motion setting is to write down a set of notes that are not a speech, but are a list of points that I want to make. You start off by thinking, right, what are the 5 things I really need to get into this judge's head before I sit down? What are the things I need to communicate? What are those points? You write those down. Then you write down everything that supports that point. So references to cases, for example, facts on the record. Once you do that, and once you decide you're going to move through your argument in that way, first of all, you have a structure, so you know what your first words are going to be. They're your 5 points. My lord, I intend first to take you to the issue of the content of this evidence, then I'll take you to the issue of the relevance of this evidence, then I'll take you to the issue of the text of Rule 31, and then I'll make some submissions on the interests of justice. Those might be 4 points that you want to set out in your note. And you've got it, it's there. You know the first thing you're going to say. That's written down. And once you've got that, and you've obviously read the case thoroughly, you've thought about it thoroughly, you know what the issues are, you know roughly where everything is in the record, you've marked everything, you've fluorescent inked all the most important bits, you'll find your ability to speak and your ability to be flexible, to know what the main issues are and to deal with them flexibly much better. The speech is a straitjacket. It's something you feel you have to finish, and it might not be something the judge is particularly interested in. This is the sad and harsh reality of appearing in court. The judge is interested in what he or she is interested in, and not much else. So if you take the attitude, oh, I'm going to finish this speech because I wrote it, then, and why wouldn't you? I mean, it's just psychologically what you would do if you wrote a speech. Then you're going to be in difficulty. So your notes, lesson number 1, don't read. How do you not read? Well, have a different note, right? If it's not in front of you like a speech, you're not going to want to read it. Set out the notes in point form. What are the 5 things I need to get across? And then have that structure your argument. And obviously the points then break down into subpoints and subpoints and subpoints. We've all sort of revised for our exams with spider diagrams with the main point hidden in the middle and sort of several offshoots, that sort of thing, right? So try that. Next time you have to do something like this, resist the temptation to write a speech and think, what are the main issues I need to get across? Now that, if I had to say, and when we do advocacy training, we're supposed to choose the one thing. We don't want to confuse people, so we choose the one thing that could be better. And that is the most important thing, I think. That's the most fundamental thing you should try and do in future. Experiment with your notes. Don't write a speech. Write things down in point form. It will allow you to be more flexible. A few points of presentation. Don't thank the judge for his question. He's already very pleased with himself for having answered it. You don't need to stroke his ego anymore. You know, being a judge is having had some real life experience of it myself, is in many ways an ego stroking exercise. Everybody calls you my lord. You sit higher than everybody else. Everybody's bending over backwards to accommodate you. You don't need to lay it on with a trowel. You don't need to thank the judge for his questions. Just answer the question. And in real life, judges, especially in busy courts, can be quite cranky and impatient. And if you're constantly thanking them for their questions, then it can irritate them. I was doing a trial once in Durban when I was cross-examining a security guard, and the judge, who shall remain nameless, interrupted all the time with criticisms of my style of cross-examination, which were, of course, ridiculous because my cross-examination was great. But, you know, she interrupted it, and oh God, I've let the gender go now, but they interrupted, and they did it over and over again. And of course, you can't get upset. So I kept saying, thank you, my lady. Thank you, Judge. Thank you. And then after about 5 thank yous, you don't have to thank me every time. I was winding her up more and more and more. So try not to do that. Just answer the question. Don't ask for permission to continue. When you stand and you're making submissions to a judge, the floor is yours. You are in control of the court. Don't ask the judge to place you in control. If the judge wants to stop you, he or she will. Try to avoid things like good morning, judge, hello, judge. That sometimes comes off a bit inappropriate. It's not that it's wrong to say good morning or hello to people. It's just every theatre has its rules and every theatre has its form. And greeting the judge in open court is not really what is done. You can say, may it please you, my lord, or my lord, I intend to do this or that, or justice, whatever their name is, I intend to do this or that. But passing the time of day, commenting on the weather, asking the judge how he or she is, it's not the sort of thing that's done. But the main thing, experiment with your notes, try not to write a speech, try to reduce your case to point form with appropriate references to the record and subpoints, and I think you'll see your performance improve in the future. But really excellent, really well done. You should all give yourselves a very substantial pat on the back. Well done. I don't propose to process out. I think we can call it a day, can we? Yes. Well done, everyone. Thank you. Oh, I do have to process it. Well, thank you, everyone.